Good morning. It is Thursday, October 29th, 2020. This is the Commissioners of Rehoboth Beach virtual special meeting. I'm called to order at 10:04 a.m. I'll do roll call. Commissioner Susan Gay.
Here.
Commissioner Dick Byrne.
Here.
Commissioner Patrick Gossett.
Here.
Commissioner Pat Caluzzi.
Here.
Commissioner Jay Legree.
Here.
Commissioner Ed Chernowski.
Here.
And Mayor Stan Mills is here. We have a full board. We have a quorum. We're able to formally conduct business. Thank you all for being here. Thank you for all those watching and for your patience while we deal with some IT situations throughout the meeting. The purpose of this special meeting is to consider and decide several preliminary motions and motions to dismiss regarding the appeals of site plan approvals for site plan review application number 0620-03 for Clear Space Theater and site plan review application number 0620-03 for Rehoboth Spotlight. No public comment will be allowed as noted on the agenda, as the matters to be heard relate to appeals filed pursuant to Section 236-6 of the Municipal Code, which only allows persons who provided written or oral testimony before the Planning Commission the ability to appeal and restate their position, and because evidence and legal arguments not on the record of the hearing before the Planning Commission may not be presented. And again, that's why we have no public comment allowed at this meeting. Speakers identified to be able to speak at this meeting under the rules noted are our attorney, Max Walton, Lisa Hatfield from his office. Speaking for the Planning Commission is Mr. Glenn Mandalis. Speaking on behalf of Clear Space and Rehoboth Spotlight is Mr. Eugene Lawson and Wesley Paulson. And speaking on behalf of the appellants, we have Marie Hatkevich, Jan Conacy, Chad Sensenig, Harvey Schulman, and John Swift. Welcome, everybody. I do want to make note that it mentions in the agenda that there is a link so that all the papers and all the documents that we have and are referring to today are embedded in the agenda and are accessible to the public through the online portal at www.cityrehoboth.com. I would like to give some preliminary notes on this meeting, and that is we will likely have to take a few occasional recesses. We will stop for a lunch break at an unspecified time. The timing of the speakers is by Max Walton. All votes will be by roll call vote, and we're reminded that we are to state our reasons for choosing our votes. And also, I wanted to acknowledge that we have received some correspondence in the matter of Clear Space, and it is not being acknowledged for this meeting, but is on file and will be available on the city online portal prior to the November 12th appeal hearing, if that takes place. At this time, I'd like to introduce you to the attorney, Mr. Max Walton, who is representing the mayors and commissioners in these matters. He will offer the ground rules and help us manage the meeting. Thank you very much.
Yes, Mayor, thank you. For the public, I just wanted to talk very briefly about that the commissioners in this case are not acting in their normal legislative role. And as the mayor said, they're really acting as judges in an administrative proceeding. I'd like to also talk a little bit about what today is not about. It's not about the legal merits of the decision of the Planning Commission. those arguments will be heard on November 12th if the appeals today are not otherwise dismissed or remanded. And it's not about whether folks like the application or not. That's largely irrelevant today. These are legal claims, contending that the appellant's appeal should be dismissed or that there was an error in the process set forth by the Planning Commission. My job is really to help guide the hearing, but ultimately the commissioners make the decision. Prior to the hearing, I established some rules and advised the party of the ground rules, and I thought we should provide those to the public here first. For the motions to dismiss will be heard first. Clear Space, Rehoboth Spotlight, and the Planning Commission will have 30 minutes to present their motion. Appellants will have 30 minutes for rebuttal. And if Clear Space and Rehoboth Spotlight and the Planning Commission have time remaining, they can provide a rebuttal. The commissioners may ask questions of any speaker at any time during their presentation if they so choose. And if the commissioners ask questions, that does not extend the time. After the motion is argued, the commissioners will deliberate and decide the motion that was just argued and any issues raised as part of that motion. If the motion to dismiss is granted, the case goes away because it will be dismissed. If it's not dismissed, then we will move on to the remaining motions. And for these motions, each side will have 20 minutes total for argument. Appellants will go first, appellees will go second, and if the appellants have time remaining, they can provide a rebuttal. Following each argument on each of the motions, the commissioners will deliberate and decide it. And then we'll go on to each motion until they're all done. I have advised the parties that the motion to dismiss will go first, and then the remaining motions, if heard, will go forward as follows. The Hunker disqualification motion, the Mandalis disqualification motion, the improper site visit motion, the community meeting motion, and the failure of process motion in that order. As the mayor said, we're going to break periodically, and we're going to break for lunch at some logical point. Mayor, with that understanding, I believe we're ready to go on the arguments, and I'm going to grab my timekeeper.
Okay.
You want to go ahead and have the motion to dismiss start?
Yeah, we'll start with the motion to dismiss. The appellants are up first, correct?
The appellees are up first.
Appellees are up first.
Correct. Mr. Mandalis and Mr. Lawson.
Mr. Lawson and Mr. Mandalis, you're up first on the motion to dismiss.
Thank you, Mayor. I plan to be as brief as possible and not to get into a whole bunch of legalese, as Mr. Walton indicated, but to essentially place before you the requirements for a perfected appeal and to argue that, in fact, they were not met. This started out with two separate and distinct decisions for the Planning Commission on August 14th. And an appeal must be to each of those distinct decisions, and each must be perfected according to Chapter 236 of the Municipal Code. The requirements generally are that there's a general statement of the grounds for the appeal and the grounds upon which the person filing the appeal believes they've been aggrieved, and finally a payment of the appeal fee. The general statement was, in fact, included in the notice of appeal and was certainly general, but it did not apply to any particular appellant. Secondly, a specific statement by the person filing indicating how they were aggrieved has not been met because it's impossible to tell from the notice of appeal who the specific statement person was and how they were aggrieved. And finally, there was a payment of $150, which is the appeal fee set by the city code. And that was for one appeal. And we've got two appeals here and therefore they didn't meet the requirements there. What we'd like to say is, even though this is seemingly meaningless to some people, when you do follow the rules set forth by the city commission and the code, you must follow them, whether you're a regular citizen or whether you're someone who's got special talents or whatever. So what I would like to argue is that when the decisions came out, there were two of them. They have been allegedly appealed, but the criteria for the appeal has not been perfected, so the motions are not perfected. Therefore, the appeal is without merit and should be dismissed. And with that, believe it or not, as short as it was, I'll turn it over to Mr. Mandalis.
Thank you, Mr. Lawson. Are there any questions for Mr. Lawson before I begin? Thanks. Let me say good morning. My name is Glenn Mandalis. I am the city solicitor, but I'm appearing today on behalf of the Planning Commission. And so the record is very clear. So our video just went out. We're back. So the record is very clear. I've had no conversations with the mayor or the commissioners on this matter or on this appeal. That would be, of course, entirely inappropriate. I've represented the Planning Commission below, and that's why I represent the Planning Commission before the Board of Commissioners here today. And Max Walton is brought in as outside counsel to represent the commissioners. My interest today is ensuring the credibility of decisions that are made by the Planning Commission. This isn't, as Mr. Walton said, this is not about the merits of the decision today. Today it's more procedural, but as counsel to the Planning Commission, I have a role to perform, which is to ensure when they make a decision, so long as it's legally sustainable, that I ensure the credibility of that decision and ensure that it's sustained by whatever adjudicatory body it might come before, in this case, the Board of Commissioners. The Planning Commission made a motion, and that's what you're hearing today, a motion to dismiss the appeal. The terminology is kind of confusing because you'll be making a motion today whether to grant or deny the Planning Commission's motion. So we'll try to be careful about the terminology, but this motion to dismiss is different than the motion you'll be making later as to whether to grant or deny it. I wanted just to mention quickly that the Planning Commission, again, it's not about the merits of the decision, but a Planning Commission has no discretion to deny an application that's been filed and is compliant with the city code. It can attach reasonable conditions, as it did in this instance on both of the approvals, but it has no discretion to deny, and that is set down in quite a few different cases in courts within our state. So with that backdrop, I want to describe to you that there were two applications submitted to the Planning Commission. One, as Mr. Lawson said, was site plan review application 0620-03 for Clear Space Theater to construct a theater building. A second one was site plan application 0620-03 for Rehoboth Spotlight to construct a building that would be separate from the theater, but would complement it. To be clear, there's separate ownership of the land. The land is separate parcels, and each of the projects was separately required to comply with the city code. So while there is a complementary nature between the two facilities, they, in all respects, were and have been reviewed separately and approved separately. 2 approval resolutions, 2 public notices, 2 public hearings. So they were separate in all respects. This arrangement where you have these complementary facilities isn't unique to Rehoboth Beach. It occurs in other places. One good example, I think, is Dogfish Head Inn Restaurant and Chesapeake and Maine Restaurant. They exist through separate ownership. They're on separate parcels. They're side by side, but indeed they complement each other. For example, they share the same exact liquor license, one liquor license for the two restaurants. So it's not that this is something new and something that doesn't exist within the city. Those two restaurants, by the way, are, I believe, over 10,000 square feet together and would have required off-street parking had they been considered one single facility. So on July 10th, following a preliminary review of the two applications, the Planning Commission voted to hold a public hearing on both of the applications, separate public hearings, but on both of them on August 14. And on August 14, that public hearing did happen. It lasted nearly 5 hours, the two hearings. And the Planning Commission did vote to approve both applications subject to conditions. 10 days later, the appellants filed their motion or filed their notice of appeal, which brings us here today on our motion to dismiss that appeal. So let's examine the notice of appeal filed by the appellants. So although the Planning Commission made two decisions on two separate site plan applications, only one appeal document was filed and one filing fee was paid. The appeal was filed on behalf of 21 different individuals, one of whom we don't believe even lives in the city any longer. So there are two arguments in the Planning Commission's motion. First is that under section 236(6)B of the city code, a person appealing a decision of the Planning Commission must pay a filing fee. The appellants didn't pay two filing fees when filing their notice of appeal, and as a result, the appeal is not perfected and it must be dismissed. Secondly, under section 236(6)A of the city code, a person appealing a decision of the Planning Commission must make a general statement of the grounds for appeal and grounds upon which the person filing the appeal believes they have been aggrieved. The 21 appellants, as Mr. Lawson mentioned, in their notice of appeal, failed to satisfy the standard, and the appellants don't have standing to bring this appeal, so it must be dismissed. So first, as to the filing fee. Again, sections 236(6) and 236-35 govern appeals of this nature. Section 236-6B provides that there's a $150 filing fee for an appeal, and that the filing fee is payable to the city on the date of filing the notice of appeal. So as a preliminary matter, there must be a payment of the filing fee in order for an appeal to proceed. Now, as Mr. Lawson said, I know it sounds kind of elementary and kind of unimportant, but it's not. And appeals are dismissed across the country for failure to pay a filing fee. So our statute on the fee is clear and it's unambiguous. The filing fee for one appeal is $150. For two appeals would be $300. There's no waiver provision. And in the documents that Ms. Womack has uploaded is the check that was used as a filing fee, and it's clearly a check for $150. One appeal fee for two appeals and 21 different appellants. So despite their awareness that they were appealing two separate decisions of the Planning Commission, they only paid one appeal fee. So their appeal.
Mr. Mandalis, can I ask you a quick question, just because I don't know? Do you
Yes.
know if the city required the appellants to pay two fees, or was there anything mentioned about them not filing or paying $300 instead of $150 at the time that they applied? Can you shed any light on that?
I can't, unfortunately. I don't know whether the city secretary mentioned it, asked about it or not. I mean, I think she sort of takes it administratively as it comes to her, and isn't always, isn't really her job, in my view, to decipher, how many appeals should be filed or how many fees should be paid. But I don't know the answer to that question.
I'm sorry to interrupt you. It was just a curiosity point.
Not a problem at all. So what I wanted to mention is that it's not uncommon that filing fees are an important matter. And by analogy, the courts of Delaware require that filing fees be paid, otherwise matters are dismissed. For example, Supreme Court Rule 20 requires this. Our Superior Court Rule 3E requires the paying of a fee, or else dropping the case from the docket. Superior Court Rule 3E requires the same thing. Chancery Court Rule 3B requires the same thing. Court of Common Pleas Rule 3E requires it. And Family Court Rule 3C requires it. So does JP Court Rule 3E. They all generally require that the clerk of court shall not file or docket any proceeding unless the required deposit for costs and fees has been paid. And as a result of these rules, Delaware courts will dismiss cases where a filing fee has not been paid. And we cited one case from the Delaware Supreme Court on that matter. So based on the appellant's failure to pay their requisite filing fees and for their appeal and of the Planning Commission's decisions regarding site plans for Clear Space Theater and Rehoboth Spotlights, the appeal should be dismissed for that reason alone. Secondarily, and as importantly, the appellants fail to meet the standing requirements. Turning back to section 236.6 and 236.35 of the city code, which is where the appellate or the appeal sections are provided. 236-6A provides the basis for bringing an appeal. It provides that a notice of appeal needs to consist of a general statement of the grounds for appeal and the grounds upon which the person filing the appeal believes they have been aggrieved. Or in other words, a person trying to bring an appeal needs to provide some detail regarding how they allege they have been injured. And appellants haven't done that here. They tried to in their response to our motion, but they still didn't meet the mark. The courts have said that standing is the right of a party to invoke the jurisdictional to enforce a claim or to redress a grievance. Standing only concerns who is entitled to mount a legal challenge, not the merits of the claim. So it's all about who's entitled to bring a claim. It's not about the merits of the claim. As Mr. Walton said earlier, it doesn't matter whether you like the project, don't like the project. It's a question of who's allowed to complain or bring an action about the project. So the courts have said,
could you reference the document that the appellants made and the date of such document where you suggest that they didn't meet the requirement?
So their initial appeal document, which is dated August 24th, 2020, and received by the city on that same date, they give, and I'll talk about it a little bit more, they give some general representations about concerns about traffic, general concerns about congestion, things that are generally applicable to all the inhabitants of the city, not a specific harm to an individual appellant in this case.
Thank you. I just want to make sure we're all on the same page with what appeal document we're reviewing.
Yeah, thanks for that. So to establish standing, the courts have said a party must have suffered an injury in fact, which is the invasion of a legally protected interest within the zone of interest sought to be protected or regulated by the statute. The invasion must be concrete and particularized and actual or imminent, not conjectural or hypothetical. Second, there must be actual connection between the injury and the conduct complained of. The injury has to be fairly traceable to the challenged action of the defendant and not the result of the independent action of some third party, not before the court. Finally, it must be likely that the injury will be redressed by a favorable decision rather than merely speculative. And that's a Delaware Supreme Court case that laid out the standard for standing. It's called Ocean Port Industries versus Wilmington Stevedores. So general grievances, the court has said, general grievances shared by the public at large are not a basis for standing. That's from a case called Dover Historical Society. General grievances shared by the public at large are not a basis for standing. The appellants want you to adopt a much looser standard for standing and simply ignore the legal standard I just described that the courts have laid out. But your role right now, as Mr. Walton said at the beginning of this hearing, is quasi-judicial. It's not discretionary. You are sitting as judges. So you have to apply the judicial standards that have been developed through the case law. You simply can't ignore these judicial principles and adopt this looser standard that the appellants are arguing for. In the case before you, the notice of appeal filed by the appellants was filed on behalf of 21 different property owners in Rehoboth Beach in various locations. Although the notice of appeal was filed with general statements regarding the grounds for appellant's appeal, there's no statement in the appeal providing a linkage between each of the individual appellants or even one of the individual appellants and the specific grounds upon which the individual appellants alleged to have been aggrieved by the Planning Commission decisions. Rather than being concrete and particularized statements of the alleged aggrievement, as the law requires, the appellants have proffered only speculative, conjectural, hypothetical, and generalized statements of how one or more of the appellants might be aggrieved. their response. Now, there is a response to the Planning Commission's motion to dismiss that tries to do a better job. And it talks about some of the individual appellants. But still, those agreements, if you look at them, they are general in nature and generally applicable to the public at large. In each of the 4 categories listed by the appellants in their notice of appeal, and those categories being people adjacent, people within 1,500 feet, people within a half a mile, and people further out than half a mile. The appellants generally recycle a universally applicable grievance that appellants will be adversely affected by some combination of hypothetical conditions, including, they mention, additional noise, additional artificial light, reduced natural light, additional traffic and associated traffic safety issues, additional parking problems, issues with architectural massing, composition, scale, and character of the neighborhood, issues with incompatibility of new construction with existing properties, lack of preservation of streetscapes, drainage and stormwater problems, and decreased property values. All of those are general agreements shared by all the members of the public, or many members of the public at least. The Delaware Supreme Court has explained that a generalized grievance shared by the population at large cannot be a basis for standing. And that's a quote from the Dover Historical Society case. Again, the Delaware Supreme Court has explained, this is the quote, that a generalized grievance shared by the population at large cannot be a basis for standing. Now, the Supreme Court went on and said that although a grievance may be widely held by the population at large, it doesn't make the grievance abstract and not judicially cognizable if individual plaintiffs can demonstrate a concrete and particularized injury. It has to be concrete and particularized to an individual appellant in this case. The individual appellants were required here to demonstrate that concrete and particularized grievance. Instead, these 21 appellants do not provide grounds upon which the individual appellants who filed the notice of appeal will be aggrieved. Additionally, while these grievances may be widely held by the population at large, the individual appellants here have not demonstrated any concrete or particularized injury, nor have they demonstrated that any of the generalized grievances are actual or imminent. Those are requirements of our state courts. And you can't apply this looser standard that appellants are going to argue you should apply. As a result of this, the 21 appellants have failed to demonstrate that they have the requisite standing to bring the appeal, and consequently, the appeal must be dismissed for both the reasons of failure to pay the appropriate filing fee and failure to demonstrate that they have standing. Either of those reasons is sufficient. Thank you for your attention, and that concludes my remarks.
Thank you, Glenn. Thank you, Gene Lawson.
Mr. Lawson, Mr. Mandalis, you have 10 minutes and I'll say 30 seconds for rebuttal if you need it.
Thanks.
Max,
I'd like to call on the representative for the appellants to speak. And who is speaking first on behalf of the appellants?
Hello.
Hello, please identify yourself.
Yes, this is Harvey Shulman. Can you hear me?
Yes, we can, Harvey.
Okay, I am speaking as an appellant, and on these two issues, please let me know when I can begin and my time starts.
Go ahead.
Thank you. Before I start, there are two other appellants who are on the line, who in accordance with the procedure set up with Mr. Walton, they've registered and they will have a statement for a minute or two. So the first person is John Swift.
Can everyone hear me?
Yes, we can, John.
Okay, great, thank you. Hello, everyone. I'm John Swift, and I live at 100 Sussex Street. I can't believe the city is spending money to pay for the planning commission's legal motions that argue neighbors who live close to the big clear space theater project have no legal right to appeal to the mayor and commissioners, especially at night when a theater will be operating. It will be the end of the quiet enjoyment of our home for me, my family, for renters who sometimes rent our home for part of the summer. How will we escape the noise from the patrons in the corridor between the two buildings, or the amplified sound penetrating through the exterior walls a mere 10 feet from my property line? What about theater patrons or students at clear space classes who will look for parking in front of our house before and after theater times of their classes? I tried to sell my home, but potential buyers were too concerned how clear space will affect us. My neighbor had to reduce the price of his home by $177,500 in order to sell his home due to clear space, and that is lowering the value of my property. If someone like me who lives right next to clear space doesn't have standing to challenge the clear space plans, who does? And my name and address are on the clear space plans that they submitted. Thank you.
Thank you, John.
Mayor, the next person with a brief statement will be Chad Sensenig.
Welcome, Chad.
Thank you, sir. Good morning. Can you hear me?
Yes, sir.
All right. Good morning. I'm Chad Sensenig, who lives at 98 Sussex Street. As a bordering property owner to Clearspace, I'm very concerned that the Planning Commission approved the Clearspace site plans with only an approximate sound transition coefficient rating on the exterior walls of the blueprints. Our testimony to the Planning Commission showed that the word approximate is not quantifiable, is subjective, and is open to interpretation. Also, no one addressed how the sound generated by the patrons in the corridor between the two theaters would be mitigated. In fact, the masonry line corridor that will potentially channel sound directly towards the bordering properties like mine. Also, Clearspace is providing no parking. It's clear there's going to be more parking and more traffic in front of my house. I find it difficult to believe that the Planning Commission was serious when they told the mayor and commissioners that the neighbors like me don't have a legal standing to bring this appeal, but I do know that their position is inconsistent with the type of transparency and citizen participation that is part of Rehoboth Beach. Neighbors like me, who will be potentially negatively affected by what's proposed here, must be able to challenge a site plan on appeal with the goal of making it better. We must also be able to challenge Planning Commission procedures that were used to minimize and devalue our input. Please do not throw out this appeal for lack of standing, and thank you for your time.
Thank you, Chad. Harvey?
Yes, sir. So there are a couple of other people who could not be on the call, but asked me to read something that they've said. One is Janice Miller, who lives right next door in the Ark, and who testified at the hearing that she probably has the dubious distinction of having the closest bedroom in the entire city of Rehoboth Beach to the theater. Her building hired a noise person to talk about noise issues. Janice has also expressed concern about the parking and the pedestrian congestion and the traffic driving down Rehoboth and making a left turn to get to the theater. Also, Bo Lauder, who lives right next door at 98 Sussex Street, adjacent to these lots, provided a lot of testimony. His statement that he sent me, do I really have to justify my standing and my so-called aggrievement? I'm very concerned about a number of issues I addressed at the Planning Commission, including the invasion from Clearspace's outdoor lighting that will light up my yard like a parking lot. And second, another kind of invasion, the privacy of my home and my back garden, which will be easily looked down to from Clearspace windows. And of course, their tall buildings will block some of the natural light that I receive and the open space I can look at now. If you throw out this appeal for lack of standing, it's not only a wrong decision, but you will destroy the confidence that residents must have in our open government here in the city. So with those individual comments, I'll get into the more general argument. I'm not sure, am I on the screen now, or I'm just, can you see me, or am I just talking?
Yes, ma'am, we can see you from your nose north.
I have a question of Mr. Schulman, please.
Yes, Mr.
Commissioner Calusi, use your raise your hand features if you would. That'll help me out. Go ahead, Commissioner.
Sure. Mr. Schulman, the last, you just read something, and I don't know who you were attributing that to, who you were representing at that moment. There was somebody.
I'm not representing anybody.
Oh, okay. Who is that you were talking, that the last one I heard?
Bo Lauder, who lives right next door adjacent to the property.
Bo Lauder. Okay, thank you very much.
Okay. Let me say that the first place to go to is the words of the ordinance. And now, as our opposition says, unfortunately, ClearSpace and the Planning Commission don't really like to talk about the words of the ordinance. They are basically asking you to rewrite an ordinance that's in the books. Because as they read, and then they soon got away from, the ordinance in terms of standing says there needs to be a general statement of the grounds upon which the person filing the appeal believes they have been aggrieved. Okay, a general statement of the grounds on which they believe they have been aggrieved. Now, Mr. Mandelis may not like this, but that's a different set of words than is used in the courts for standing. And the courts apply a strict standard. Now, we believe, and we'll cite some cases, that the appellants here meet the judicial standard. They absolutely meet it. But when they're trying to tell neighbors and neighborhoods that in a hearing before the mayor and commissioner, they want to apply court rules, that's not what you wrote when you wrote the ordinance. You wrote these standards. Not only you wrote it, I will say that Mr. Mandelis and I were in the same room, and we were both on the drafting committee for this ordinance. And there's a lot of things that are not in the ordinance that at the time Mr. Mandelis wished had been in the ordinance, but they're not. And his concept of standing being the same as judicial is not in the ordinance, but we'll show how it's been met. Secondly, I'd like to make the point that the motion to dismiss here is to dismiss the appeal, not to dismiss plaintiff A or appellant B or appellant C. It's to dismiss the whole appeal. And what they still haven't answered is the principle that applies in Delaware, even in the courts that we've cited in our opposition. Courts specifically say that if a group of people are bringing a complaint, and if only one of them has standing, that's sufficient for the complaint to continue. That's the law in Delaware. And it was specifically done, by the way, in the case of the cases that Mr. Mandela cites, the Dover Historic Societal case. That's an interesting case also because there were two groups of people there, people who lived within the green and people who lived outside the green, but claimed to be aggrieved by what was in the green. The people in the green, there wasn't even any distance involved. I think the green in Dover is something like 45 or 50 acres. So what the Supreme Court did is said, if you live in the green, whether you're the neighboring property or you live 4 blocks away, you have standing to challenge this construction in the green. And then if you live outside the green, we want a little more information because we then want to know, how close are you and some of the other details. But that was a case where, there were two groups of people, inside and outside, and the one inside distances were irrelevant. So let me,
Mr. Shulman, I have a question for you, because one of those cases you cited is actually one of mine. It's the Newark Landlord Association case.
yes, sir, I noticed that.
Actually my case.
I
So
noticed it.
I have just a quick question. I don't mean to take your time. In all of those cases, they were represented by a single counsel, or a group of people was represented by a single counsel. And it wasn't like there was 20 pro se individuals who were going forward. The case was allowed to proceed. And I will grant you, if the commissioners find standing for one individual, then the appeal goes forward. But can you explain to me how, if you have in this case 20 individuals who are pro se, why they don't have to each establish their standing to continue as an appellate?
Well, first of all, there's no precedent for that. I mean, I found no case that says when a group of people come in with a lawyer, that they get treated differently than the people who come in without a lawyer. So what are we?
I didn't mean it that way.
Well, I know you didn't. I know you didn't, but that's the.
Doesn't each individual have the burden to establish standing that they can bring a case?
They do not have, they do, whether a group is represented by a lawyer or not, it's a group of people. It's a group of people who filed the same appeal or the same complaint. There is not a single case that I have seen which says if you're pro se, then they can pick you off one by one. But if you put a lawyer in front of you, oh, then as long as one of you is.
Perhaps my question was a poor one, and I'll ask it in a different way. If each of the individual appellants had filed a pro se appeal and paid a filing fee, wouldn't each of the individual appellants have to establish standing for their own appeal?
Well, that I don't know, because in this case, all of the appellants, as often happens in court and often happens in city agencies. Last year, I think there were 40 appellants who filed one appeal, or 2 years ago, on the Park and Shade Tree Commission. So I can't get into the hypothetical of if each one have done that. This has been done repeatedly in the past in Rehoboth Beach for years. When I was on the Planning Commission, we had groups of people who filed as a group, whether they were 5 or 7 or 9. Nobody said, well, each one of you has to show standing. So I just don't think that's the law. And in this particular case, the notion that it's impossible to identify who is making what claims, it's impossible to say that it's impossible to identify. We specifically said in group 1, this is not a lawsuit, so it's not a class action, but group 1 was people whose property is adjacent. ClearSpace gave you the maps. It shows whose property is adjacent. There are 5 of these people whose property is adjacent. The Sensonigs, Bo Lauder, John Swift, Janice Miller. These are people whose property is adjacent. And if you read the appeal notice carefully, there are different harms alleged for different groups of people. So the people who are adjacent stated that, among other things, there was harm from noise, there was harm from light. Those things were not stated for people who lived a few hundred feet away. Okay, it is true that everybody who lives within 1,000 feet. Why 1,000 feet? Because the Planning Commission required ClearSpace to reach out to people who live within 1,000 feet because of the concern about parking and traffic. By the way, I live 800 something feet away. I was never reached out to. Somebody could have gotten my address from City Hall and sent me a postcard or something. But in any event, the second group of people are people who are not immediately adjacent, but are within that 1,000 feet of distance that the Planning Commission itself was concerned about. And some of the claims, the harm that we assert, like traffic and parking, are common to the people who live next door. But we didn't assert noise. We didn't assert light. We didn't assert removal of our unobstructed views. So this is not a one size fits all. Each group was put together based on where it lives and what particular harms they suffered. Now, Mr. Mandelis would like you to say, well, what's the harm from light? What's the harm from the parking? That's all in the record. People can disagree. Is parking going to be a problem or not be a problem? But you can't get into that at the standing level. The courts don't even get into that at the standing level. There is sufficient evidence in the record and in the appeal notice to say this is a parking problem. I submitted evidence specifically that says when the Seashore Striders have their Sunday morning races and there's free parking even at the meters. I, living 800 feet from Grove Park, have my driveway blocked and people parking in front of my house with the Seashore Striders, who typically attract less people than the theater. And so, as to me and others in my group who were in that distance, there is a specific problem of parking. Okay? Other people who live a mile away didn't get into parking, they got into other things. And if you, so let me go a little bit more on the legal side. So in Delaware, the rule is absolutely clear. There's a case called Custician versus Town of Belafonte, 2006 Law Week 1520199. That's a Superior Court decision where the court says the threshold issue is whether the person possess standing. And they quote, you have to be aggrieved, yada, yada, yada. And this is what they say. The court finds that Custician is an aggrieved person within the meaning of the code because he is the owner of the property that is adjacent to the applicant. Thus, he has standing. Do we really need to say anything more about the people who live right next door? Or even the people who live within 1,000 feet? And then beyond that, the assertions are that everyone is a regular user of this intersection. And I won't bore you with all the details, but there is a Third Circuit Court of Appeals site, which is a federal appeals court that includes Delaware, in the case of Interfaith Community Organizations versus Honeywell, 399 Fed 3rd 248. It's a 2005 case where they looked, there was a complaint about a building, about a site that was polluted. And among the people complaining about it were people who lived from a quarter of a mile away to 2 miles away. And what the court said is those people who lived that distance, so they weren't right next to the river, they couldn't smell it because they lived there, but they lived quarter of a mile, 2 miles away. They were regular users of that area, including specifically as walkers or bikers. But as regular users who go to that site, just like people here, who bike here, who jog here, who walk here, who drive here, they have standing. And we're not talking, this is not New York City, where we're talking about 5 million people who have standing. It's not unusual for a few hundred people to have standing. But it's different types of harm here depending on where they live. So let me go to a couple of other things.
You have 10 minutes remaining.
Thank you for reminding me. So we're not talking about all members of the public. And you are not a court, you have to follow your ordinance. And while we meet the judicial standards for standing, as the cases I've read, clearly we fit in the category of next door neighbors or regular users. That's we meet the lower level of standing in your ordinance, which is a general statement of why people believe that they are aggrieved. Let me go now to the question of the filing fee. You know, in 17 years on the Planning Commission, I've never, ever seen anything thrown out for lack of a filing fee. And there have been people who got their check in the next day. It's almost an insult here to the city secretary who's been doing this for 15 years and who is a clerk of the year in Delaware and knows what she's doing. When the question was asked to Mr. Mandelis, well, did anybody ever tell them, you know, that they needed a more fee or whatever? Ms. Womack knows what she's doing. And ever since we filed this thing, which is 2.5 months ago, not a single person representing the city, not Ms. Lynn, not Ms. Womack, no one has said, oh, you know, you messed up on the filing fee. It's not Mr. Mandelis's role to tell us what the filing fee is. It's either the city attorney's. Now, maybe he was playing that role as a city attorney. I don't know. He has so many hats in this. I don't know what his position is. But if he's truly representing the Planning Commission, you know, then that's the Planning Commission's view of this thing. This case is so unusual because, did you notice the case has the same number? The number that they gave you earlier, it's the same number, but after each number, they put a different name. You know, 2020-237 clear space, 2020-237 row with spotlight. That's not the way things work in court. When different complaints are filed in court, when different applications are filed, there's a different number. There's a different number. One case gets one number. And to put a different name at the end of it doesn't make it a separate case. So for purposes of appeal, I think the appellants reasonably assumed that this is one case. Not only that, the appeal is being taken of what the ordinance calls the entire final action. That's the word you use in your ordinance, the entire final action. This was the approval of a theater complex. It goes to the merits, and we'll get into it if we get that far, but this never should have been one application. Excuse me, never should have been less than one application. These were two, this was a lot that was broken into two lots. We know why, to deal with the parking issue. Okay, so it was very clever, and we'll figure out later maybe if that was appropriate, but it's still one final action. One building can't exist without the other because the infrastructure is tied together. Look at the record, okay? So beyond that, the cases that Mr. Mandela cites for the courts, well, those are court rules. Again, those are court rules. So when a court rule says the secretary or the clerk of the court shall not docket and shall return, that's specifically what a court rule says. Here, Ms. Womack accepted the fee, took a receipt for it. There's nothing in the statute, in the ordinance here, that it says if somebody doesn't pay the right fee, that it gets thrown out. So there's lots of remedies to this. I mean, how do you justify in a case like this throwing out the neighbors when ClearSpace paid 0 fees? 0. And you know, we can get into that at a later time, but this was not a, yes, the building inspector referred this to the Planning Commission. And on a referral, there's no fee, but this shouldn't have just been referred. We quote in our pleadings, there, because this was a development of an area of of 10,000 square feet or more that related to more intensive use. Has nothing to do with parking. More intensive use. It's one of the specific categories requiring site plan review. They should have paid a fee. They should have paid at least one fee, maybe two fees. So this is great. You know, the neighbors who look at this as one final action, who see no fees paid by the applicant at all, who reasonably relied on one case number for this case. And
4 minutes remaining.
thank you. Somehow we're going to be thrown out? No, this has never happened in Rehoboth, and you will be turning upside down the transparency and the public participation for which Rehoboth is known if you toss this out on standing grounds. I will reserve my 3.5 minutes, if I may.
Mr. Schulman, you can keep going because you don't get a rebuttal.
Oh, okay. Well, I'll assume then the other side won't bring up anything new, but thank you. Okay. Well, you know, I'm not known for talking at length and using all my time. So therefore, I think I will give up my 3.5 minutes, my 3 minutes, but not to the other side. I'll give it back to the mayor and commissioners. And please don't ever anybody say that I took more time than I was allotted. Thank you.
I'd like to ask you the same question I asked Mr. Mandalis. Were any of the appellants requested to appeal fees at any time?
Were any of them
when they filed, did anyone request to them that they, or say to them, well, you should pay $300 instead of $150?
Absolutely not. The person, and we can get her on the line if you want, but the person who physically filed was Jennifer Dunn. She went there with the check. Her initials are on it. Ms. Womack, as she often does, properly insisted that Ms. Womack should make a copy of the check, for date it, initial it. Ms. Womack. Ms. Dunn walked out of there thinking she did everything that needed to be done until these motions came in. If we had been asked, believe me, we would have come up with another $150.
Harvey, are you referring to Jennifer Duncan, D-U-N-C-A-N?
Yes, I'm sorry. Yes, sorry. For me, it's only 8 o'clock in the morning, so I'm half functioning by leaving off a lot of things.
Thank you very much, Harvey.
Max, I have a question, a procedural question. Okay.
Mr. Gay?
Yes, because, you know, both the filing fee and the standing issues have been addressed here in these statements. But my understanding was we'll be voting on them separately. So I'm wondering if for discussion purposes, we should also separate them. And maybe discuss the filing fee first and then the standing or whatever.
That's a wonderful idea. Super. We'll do it that way. But now Mr. Mandalis and Mr. Lawson get their 10 minutes and 30 seconds, which they've reserved. So I'm gonna hit start now, okay?
Max,
Commissioner Sharnowski, can you wait until after their rebuttal, or?
My question relates to Mr. Schulman, so I'd like to do that first.
That's fine. Mr. Schulman, you still have 1 minute, 30 seconds.
Maybe I should filibuster for 1 minute and 30 seconds and not have to answer the question. Okay, sorry, go ahead.
Mr. Schulman, you referenced city code and procedure that differs from the standing that Mr. Mandela stated. Can you just reference the city code number that you were referring to?
Yes, it's specifically in our pleading, and it is code section 236-35, and it talks about when you file a notice of appeal, you have to file a written notice consisting of a general statement of the grounds for the appeal, and then general statement modifies, and a general statement of the grounds upon which the person filing the appeal believes they have been aggrieved. We didn't even state this as people's belief. This is all based on evidence in the record below.
All right, thank you. You answered my question. Thank you.
Thank you.
Thank you. Gene Lawson and Glenn Mendelis, you have 10 minutes for rebuttal.
Can you give me just 1 second?
Oh, hold it while we set the clock.
I'm ready now.
Okay, go ahead, please.
Thank you, Mr. Mayor. I just want to say one or two minor things. It was alleged that the citizens were being denied review or participation in this process. And I would merely say that ClearSpace has followed the code as written and not as they wished it was written. And they have not denied anyone the opportunity to speak or to participate. And I think it behooves the commission to be aware that this code section and this code is not written in the most clear language in the world, but it has been followed pretty consistently by ClearSpace. Mr. Mendelis.
Thank you, Mr. Lawson. I'd like to start with the standard for standing. And again, the appellants really want you to adopt this very loose standard and stop right at the language of the code and not apply the way the cases have developed and the way the law has developed. And let me try to explain why you don't stop just at the city code section and why you require the standard that's been developed through the cases. So in state law, there's a standard set up, just like there's a standard set up for an appeal of a planning commission decision, there's a standard set up for an appeal of a board of adjustment decision. That's in Title 22, and it's titled Appeals to the Board, Title 22, Section 324. That section says, appeals to the Board of Adjustment may be taken by any person aggrieved or by any officer, department, board, or bureau of municipality affected by any decision of the administrative officer. This is the important language. Such appeal shall be taken within a reasonable time as provided by the rules of the board by filing with the officer from whom the appeal is taken and with the board a notice of appeal specifying the grounds thereof. So the only requirement is that you specify the grounds of your appeal under the state code section for appeals to the Board of Adjustment. But I can tell you there are case after case after case of Board of Adjustment appeals that apply the legal standard to standing. Not just the standard that's listed in this section 324 that's specifying the grounds thereof. That's the language, specifying the grounds thereof, just like our city code says specifying the grounds thereof. But in case after case after case, when the standing analysis is done, it's always the court developed standard, which is there a particularized harm? Is it concrete? Is it not hypothetical, but actual? That's the standard that you have to apply. So, and in this case, so there are, a few cases that Mr. Schulman went through. He mentioned, but all those cases I can say are distinguishable. He mentioned, for example, the Dover Historical Society case. Well, that case, yeah, it did say you have standing if you lived on the green, but that case was all about the survival and the sustainability of the historic district. So the case said, if you live in the historic district, you have standing. This isn't a case about a historic district that we're dealing with today. We're dealing about with a project that's in the commercial district. And the reason that most of the cases Mr. Schulman cited are distinguishable is because he talked about people who have residences that are either in the city's most intense commercial district and people who have residents who happen to be living in a residential district, but that residential district backs up to the commercial district. So all the properties behind the ClearSpace and Spotlight properties are in a residential district, but ClearSpace is in a commercial district. So what you have to be aware of is that there should be no expectation by a person living in the commercial district that they're going to always have a residence beside them and not have some commercial structure that is allowable under city code being built in that area. And that's why the cases are distinguishable. There's an election here to live near a commercial district, and there should be an expectation that something in that area is going to go up of a commercial nature. As to the individuals that spoke, Mr. Swift spoke about noise, parking, and property values. I listened closely. Those are generalized concerns shared by many of the neighbors and people throughout the city. Mr. Sensenig talked about noise and parking. Again, generalized concerns. Mr. Louder, Mr. Schulman went through Ms. Miller and Mr. Louder. There was noise, parking, congestion, lighting, natural light. Again, generalized concerns. In fact, at one point, Mr. Schulman said that parking and light may or may not be a problem, but we don't get into that at the standing level, he said. But you absolutely do get into that at the standing level. You have to show a concrete and particularized harm, not something that's hypothetical.
5 minutes.
Thank you.
5 minutes remaining.
Thank you. You can't say parking might be an issue, and that gives me standing. You can't say light might be an issue, and that gives me standing. You have to show a concrete, particularized harm to a specific appellant, and they haven't done that here. Ms. Miller, for example, who lives in the Arc, well, again, she has a residence in a commercial district. Many residents in the commercial district suffer harm from a commercial establishment going up next to them, but that's not a particularized harm. When somebody chooses to live in the commercial district, that's an expectation. Same with the properties that are behind. Mr. Swift, Mr. Sensenday, Mr. Louder, they live in a residential district that backs up to a commercial district. They don't have a harm that is concrete and particularized or somehow individualized and distinct from other people who back up to a residential or to a commercial district. The individuals within 1,000 feet, again, they were generalized concerns about traffic, parking, and character of the neighborhood. Let me talk just for a moment about the filing fee issue. It was almost comical that Mr. Schulman would argue that, they had a good faith belief that it was one decision because the city used some numbering system that led them to believe that. Let's be honest here. There were 2 public notices. Every time these things got noticed, there were separate public notices. There were 2 properties, 2 owners, 2 separate public hearings, 2 separate approval resolutions, 2 separate votes by the Planning Commission. I mean, everything in every step was two separate actions. So to say that the numbers are the same, they did clarify that it was clear space and then spotlight. To say that that was so confusing that they thought there was only one action by the Planning Commission, that's simply disingenuous. So we agree on one point, that if you find standing for one individual, then at least that appellant's case goes forward. We don't think that any of them have demonstrated the kind of concrete and particularized harm that's necessary on standing. And we do think that the fee issue is one that you should consider, as the courts do in the state. Thank you for the time, and I'm happy to answer any questions.
Thank you very much. So at this point,
May I
yes,
ask
sir.
a question? There's a clarifying question. Mr. Lawson, in your papers, and I don't believe you said anything about it here today, you made a complaint that there was not signatures affixed to the notice of appeal, and that there was no indication that the appellants indicated that they were appearing pro se in their appeals. Is that still a component of your appeal, or is that something the commissioners need to resolve, or can I cross those off the list?
I think if they're taking the position that there are 21 appellants, then I think the fact that no one signed it and took responsibility for the filing is still in existence.
Thank you.
All right, at this point, the appellees have had their 30 minutes. The appellants have had their 30 minutes. At this time, we turn it over to a discussion only among the commissioners. I would like to, as Commissioner Gay suggested, take the individual components of the motion to dismiss one at a time. And how I would like to handle this is I would like to start first with the failure to pay, but the process for this and the future motions is I would like a motion and a second first, and then discussion among us so we know exactly what we're discussing. And then after we're satisfied the discussion is completed, we will conduct a formal vote by roll call. So I'll turn it over to the commissioners for a motion and a second to start. Commissioner Gay has her hand up.
I'm waiting to discuss it. Hold on, I have to find it. You can take somebody else.
Yes.
Commissioner Calusi?
I will go ahead and make the motion that the appeal be dismissed for failure to pay the proper filing.
And do we have a second?
I second.
Who was that?
Jay.
Commissioner Legree seconded, and first original motion by Pat Calusi. Now I'll open it for discussion. We have a motion on the floor moving that the appeal be dismissed for failure to pay the proper filing fee. Commissioners, discussion?
Yes, I have.
Commissioner Gay? Yes, ma'am.
I have several points, and I really disagree with Mr. Mandelis on this one. First of all, it never occurred to me that an additional $150 would be due. I believe that any reasonable person would conclude that it's one appeal, and I want to state some reasons why I think that. First of all, as has been mentioned by the appellants, it was indeed one application, 0620-03. And on each of the agendas for the preliminary hearing and for the public hearing, it lists that the applications have been filed by Wesley Paulson, owner of the property. Throughout the preliminary hearing and the public hearing, numerous references were referred to as the properties being intertwined, as being a campus. But the stage was really set early on in the preliminary hearing when various planning commissioners asked how this review would proceed, because it was unusual to have this sort of two-part application. And at that point, Mr. Mandelis advised that the buildings are intertwined, but they should consider them collectively as you go through the process. At that point, Commissioner Strange, who is the urban planner on the Planning Commission, said that from a land use perspective, the entire project is dedicated to a cultural endeavor, but that the buildings don't stand on their own. To which Mr. Mandelis replied, ultimately, the entire project stands or falls as a collective instead of two separate applications. All right. In the responses, a couple of other points. In responses to the appellant's motions, the Planning Commission refers many times to the 5-hour public hearing. Well, if one is going to be completely accurate, it was more like 4.5. But the point is that time block was for both purported hearings. But actually, the hearing for Clear Space was the bulk of that. The hearing for Spotlight was 30 minutes. And in the content of those hearings, the issues were mingled. In other words, there were issues related to the Spotlight building discussed during the Clear Space hearing and vice versa. In addition to that, the resolutions for approval for the two votes, hold them up here, are nearly identical. They have the same conditions. They're identical. The only difference is in the reference of one building to the other. And in fact, they're conditional. One is conditioned on the approval of the other. So, and I do believe that because of the chapter, it's 236(6) of our code. It says, if any person shall be aggrieved, an appeal of the final decision must be taken. So the other thing that I'm disheartened by, and I really think it's unjust, is, and I believe one of the appellants said this at the beginning of his statement, I don't believe the entire planning commission voted to put forth this particular motion to dismiss, because the paperwork was received before they had their executive session. And it's hard for me to believe that members of the planning commission would vote to charge their neighbors an additional fee on such grounds. That's all I have.
Anybody else, commissioners? Commissioner Calusi?
Yes, so we are acting in a judicial mode, and we are looking at these motions specifically. And it seems that an additional $150 to be paid could have possibly been paid. I guess what actually just convinced me that this appeal should be dismissed is Mr. Mandela said, and I will repeat most of what I think I heard there, that they were always looked at as two different applications. There were two public notices. There have always been two things that were filed for each one. And I'm perhaps well, can if you have that information, you can repeat it. But it was treated all along as two separate things. And so while I thought, well, what's the big deal? Pay $150 extra. If we are looking at this as judges in terms of what is actually legally, then I have to think that they should have paid two fees.
Any other commissioners? Well, I will offer then that I do think it was confusing that there was one number issued for both Rehoboth Spotlight and Clear Space. The city has not since come forward and articulated a position whether additional funding is required. And if they did come forward, I believe it's easily cured. If there's no other.
No, I have one question for Matt here. Max, if in the judicial system, if a court filing fee was required and it was omitted for whatever reason, unintentional, I guess, would the court system notice the filer and give them a period to cure it?
Don't know that I've ever been in that situation where it was. Generally, though, the fee is paid at the time the appeal is filed.
And if it wasn't paid in full, then it would not be accepted.
Generally, correct.
In this case, it was accepted.
Correct. Yes. Correct. It's a little bit of an odd situation, because certainly if you're an attorney and you file, it's an electronic filing system, and we automatically pay those fees to our credit card. So, you know, in the olden days, we used to do it that way. Filing. Questions?
Any further questions from the commissioners? If not, I'm going to close the discussion of the commissioners and call the question. The motion on the table is that the appeal be dismissed for failure to pay the proper filing fee. So therefore, a yes vote means
the appeal will be dismissed.
The appeal will be dismissed, and a no vote would mean it's of course not dismissed. Remember, I'm going to do a roll call vote. And we need to give our rationale, the reasoning for why you chose to vote your particular way, please. So again, call the question on moving that the appeal be dismissed for failure to pay the proper filing fee. Commissioner Byrne?
I vote yes. I feel that it was clear to all that there were two separate properties here. There were two public notices given. There were two separate actions all along the way. There were two separate hearings by the Planning Commission, two separate votes.
Thank you, Commissioner. Commissioner Calusi?
I vote yes as well. Again, as I mentioned earlier, there were two properties, two public notices. There were two separate actions, and the Planning Commission voted on the two separate properties. So I vote yes for those reasons.
Thank you. Commissioner Sernowski?
This is a tough one. I vote no. I think that if based on the filing fee, if it required two filing fees, it should not have been accepted if two filing fees were not given at the time of submission, and there should have been a notice and a cure period.
Thank you. Commissioner Gay?
I vote no. Also, as I stated before, the decision on this project, and that's what's being appealed. The appeal is the final action of the Planning Commission, and that final action by their own attorney's statement is a collective and not two separate applications.
Commissioner Gay, do you incorporate the reasoning that you put on the record previously as part of your vote?
Yes, thank you for reminding me of that. Absolutely. Thank you.
Thank you. Commissioner Gossett?
I vote no on this. The applicants paid the filing fee of $150. That is what was requested by the city. And my curiosity, not curiosity, but how could there have been a second filing fee required if there was only one application number? Where would that second fee be applied to? And also in other instances, there were fees that were less than was due, was always given an opportunity for a cure, an opportunity to make up the difference or what have you. In fact, I remember one instances when I served on the Planning Commission that the fee was received, but the check bounced. So the city then gave the opportunity to reissue a check, or actually they had to pay it in cash. But so there's always an interesting time or an opportunity for a cure. But again, with one filing number, I don't see how a cure could be offered because there was nothing to apply a second fee to. Thank you.
Thank you. Commissioner Legree?
I vote no against the dismissal for the same reasons that have been stated. You stated them, Commissioner Gay stated them, Commissioner Gossett just finished stating them. ClearSpace commingled the terms. There was only one filing number, and I think we should give the appellant a chance to pay the other 150, or better yet, give it a new number as what should have happened. And for those reasons, I vote no.
Thank you.
Commissioner, can I ask for a clarification? I know you referenced Commissioner Gay and Commissioner Gossett's statements. Do you incorporate those as part of your?
Yes, sir. Yes, I do. Can I just say yes? Yes, I do.
Yeah, I just wanted to make that clear for the record. So just say yes.
Thank you very much.
I would
Thank you
like
very much. And the chair also votes no, incorporating the reasons for the other commissioners that stated no, and for the reasons that I cited earlier. Therefore, the motion fails, meaning the appeal will not be dismissed for failure to pay the proper filing fee. Thank you. Hold on one second. Thank you. Next on our docket will be to consider the three standing motions.
Well, just to be clear.
Yes, sir.
There's one standing motion and there's three categories folks who said they had standing, as set forth in the appellant's papers. And so I thought the commissioners will, but one way you could handle that is handle each group, the people who live adjoining, the people who live within 1,000 feet, and then the other folks.
So we'll take each one individually.
It's
All right.
your pleasure, but
All right. So we've got, three standing motions broken out there. Again, our process is to make a motion and a second, and then go to discussion and then conduct the vote. I'll entertain a motion. Again, I'm looking for a motion to move, in the affirmative. Everything's in the affirmative. Move that the appeal be dismissed due to lack of standing as to appellants who own property adjoining the project.
Are you ready for
Somebody-
the motion?
Oh.
Can I make it now? Or
Yes, please.
I hereby move that the appeal be dismissed due to the lack of standing as to the appellants who are, oh, we're talking adjoining the project.
Do I
Second,
have a second? Commissioner Cluzzi seconded. So we have a motion and a second to, moving that the appeal be dismissed due to lack of standing as to appellants who own property adjoining the project. Opened, for commissioner discussion. I don't see anybody discussing it. I will offer my opinion that I think this is, probably the easiest of all decisions on this motion, because I do believe that all the property owners adjoining the project, do have standing. Is there any other discussion? If not, I'll close. Oh, Commissioner Sernowski.
Sure, I'll offer some thoughts on this. I certainly believe that the residents adjoining have standing. What I'm having trouble in my own mind is establishing that the concerns within their standing are concrete, particularized, actual or imminent, and not conjectural or hypothetical. All of the items listed as grievances are subjective. They are hypothetical. So that's where I see there a challenge there, not in that they don't have standing based on their concerns and where they're located, but that they failed to establish grievances that are not generalized or hypothetical.
Thank you. Any other commissioners?
Yeah,
Commissioner Gossett, please.
yeah, thank you. I just, to follow along that thought process though, in reviewing the applications and what have you, I believe also that ClearSpace and the Planning Commission had identified those issues of concern, traffic, congestion, parking. So I think they do have actual issues because they've been identified by, if you will, the Planning Commission and ClearSpace themselves to address these issues. So I just see that as part of the record, that they're there.
Commissioner Paluzzi?
I would agree with Commissioner Szymanski. They are generalized, and although Commissioner Gossett talks about the fact that, the Planning Commission mentioned those potential issues, they are potential issues, and in fact, it was mentioned that by Mr. Shulman that seashore striders sometimes causes generalized problems, and there are many other events in the city that cause things that are generalized. And so, something eventually will be built on that property, and it'll be the same thing. So I think the whole idea of the generalized issue is an issue that I think they will end up lacking standing.
Mayor,
Commissioner Gay?
I have a comment about that. In that, first of all, all of the court cases that were cited show that adjacent property owners have standing, almost by definition. So I thought at the beginning that's why there wasn't much discussion on it. Now this topic has come up about general. I'll just say that part of the reason it's general is because the building hasn't been built yet. At the same time, one of the appellants who spoke today specifically mentioned quantifiable issue on noise. And part of the problem is, and I don't want to get into the merits here, but part of the problem is the applicant hasn't been very specific. Without controls on the project, then the problem is not just general, the problem is magnified. And quite specific, but that's all I have.
Commissioner LeGree?
In order for me to say that an adjoining property owner has no standing would be that I would have to say an adjoining property owner will never feel impact from the structure, from the building, from the activities that go on there. And I believe that adjoining property owners will feel impact, and I believe the courts would hold that they have standing without being specific of how many decibels or how many cars have to park in front of their house or any other specific types. If they're adjoining, they should have standing.
Thank you. Commissioner Srnowski?
Yeah, so some of the concerns that were mentioned, which would give these appellants standing, parking, noise, congestion, all of those things are considerations now with clear space being in the city of Rehoboth, and would be with anything going in at that spot. If there were 3 5,000 square foot restaurants going on those 3 lots, so all of these things they're part of Rehoboth. They're part of the landscape of Rehoboth. They're not going to be specific to one property owner over another that's abutting commercial property. In that mind, they are overly generalized and are not specific or concrete.
Thank you. Any more? Commissioner Calusi?
And following in that same vein of Commissioner Srnowski, I think about other places in the city. For example, Blue Moon, they have music in their restaurant, and you're going to have an issue like that no matter where. I mean, you can't. I think we're taking away the ability, if this appeal isn't dismissed, for this property not to be of any value to anyone to purchase, because then it's going to be really difficult for the buyer to then build a commercial property that someone isn't going to disagree with. I just as a concern. We're looking at the landscape of Rehoboth, and I think you see that you have residential backing up to commercial in a lot of places. And I think that is part of what we have as again, therefore, general.
Thank you. Commissioner Gay?
I just want to respond to what Commissioner Srnowski said about the possibility of 3 separate restaurants on those 3 lots. Talking about hypothetical, that's pretty hypothetical. It hasn't happened. What the clear space plan is before us, it's real. Okay.
If there's no further discussion, I'm going to close commissioner discussion.
I would just like to clarify the names of the people, as I understand it, who would be subject to this motion. And that's Swift, the Sensings, Miller, and Louder.
That's 4.
5. This is Mr. and Mrs.
Mr. and Mrs. Okay, so that's 5 adjacent property owners. If there's no further commissioner discussion, I'm going to call the question, and a motion on the floor is that the appeal will be dismissed due to lack of standing as the applicants who own property adjoining the project. That means a yes vote means the appeal would be dismissed due to lack of standing for the adjoining property owners, and a majority no would mean that the appeal continues. Commissioner Calusi?
I vote yes, that the appeal be dismissed due to lack of standing of the appellants who own property adjoining the project for the reasons I have stated earlier.
Commissioner Chernowski?
I vote yes, for the failure to the appellant to demonstrate an invasion of a legally protected interest, which is concrete and particularized, actual or imminent, not conjectural or hypothetical, and they fail to allege an actual concrete injury.
Thank you. Commissioner Gay?
I vote no because I think that it's very clear that adjacent property owners have standing.
Do you incorporate in your reasoning your statements from previous that
Yes.
you stated previously?
Yes.
Thank you. Commissioner Gossett?
I vote no. I think our code 236.6A does not require specific grounds. And that's what we're here today, is to determine if our citizens meet the criteria of the standing of our code. If you're an abutting or neighbors, were previously abutting neighbors who economic interest and welfare would be imminently aggrieved by this development.
Thank you. Commissioner Legree?
I vote no for the reasons I stated before, and I will recap. To say that adjacent owners will feel no impact is something that I cannot agree to. So I vote no.
Thank you. Commissioner Byrne?
I vote yes to dismiss. I'd like to incorporate Commissioner Chernowski's comments as my rationale, or at least a part of my rationale. I've heard only generalized concerns, not particular, not specific. The concerns I've heard are true all over our small city of Rehoboth Beach, and are true in much of eastern Sussex County. And while I understand concerns by the adjoining neighbors, I don't feel that they have really any more concern than someone who might live a half a mile or a mile down the road and is experiencing the same generalized concerns.
Thank you, Commissioner Byrne. And the chair votes no for the reasons I articulated earlier, and incorporating the reasonings of Commissioner Gossett, Commissioner Legree, and Commissioner Gay. With that, the motion fails, and meaning that the appeal will not be dismissed due to lack of standing as to appellants who own property adjoining the project. Next, we're going to go to the second motion having to do with standing. I'd like to entertain a motion moving that the appeal be dismissed due to lack of standing as to appellants who are not adjoining the property or the project, but who live within 1,000 feet of the project. Do I have a motion, please?
Yes, Mayor, I hereby move that the appeal be dismissed due to a lack of standing as to the appellants who are not adjoining the project, but who live within 1,000 feet of the project.
And do I have a second?
A second.
I have an original motion by Commissioner Byrne and a second by Commissioner Sernowski, moving that the appeal be dismissed due to lack of standing as to appellants who are not adjoining the project, but who live within 1,000 feet of the project. I'd like to open this to commissioner discussion, please.
Can I ask a procedural question?
I'm sorry, Commissioner Gay first, and
That's all right. If he wants to ask a procedural question, go ahead.
go ahead.
Procedural question for Max. Can we incorporate our previous comments from the previous motion?
Yes.
Just speed things up, or okay.
Yeah.
Yeah, you know, I mean, the one thing I'll say about this one is ClearSpace was very specifically asked to reach out to property owners within 1,000 feet, you know, and why would they have done that? Why would they have been asked to do that by the Planning Commission if we didn't think that those people had, in this case, standing, you know, would be impacted by the project? And if they're impacted by the project, then they have standing. And if they're impacted by people who live, you know, several miles away, but being within 1,000 feet does bring up those very specific problems, especially with parking that Mr. Schulman mentioned earlier, because he's about 800 feet away, and the parking is an issue from the examples that he gave. And again, the reason some of the examples are from other conditions is because this building hasn't been built yet. So that you have to go on the evidence you have. Anyway, I think the main thing is that throughout the application process, this 1,000 feet has been seen as you know, going to be a special reach out to by the applicant to discuss the impact of the project. So for that reason, I think all of them should be. I think all of them have standing.
Thank you, Commissioner Sernowski again.
That was the holdover, but I'll say that I don't agree. I don't disagree that geographically that these people are affected. But again, I think the appellants have failed the second part of this standing, which is to demonstrate an invasion of a legally protected interest, which they failed to do.
Any other commissioners? I would like to say that I don't know whether the 1,000-foot perimeter is arbitrary, but it was picked up by the Planning Commission, as Commissioner Gay mentioned, and therefore I think it does have relevance, and I do think those within that area do fit within the definition of having standing. Any other commissioner comments? If not, I'm going to close commissioner discussion. And we'll call the question. The motion on the floor is that the appeal will be dismissed due to the lack of standing as to appellants who are not adjoining the project, but who live within 1,000 feet of the project. That means a majority yes votes means that the appeal would be dismissed, and a majority no votes would mean that the appeal continues. Therefore, I'm going to call the motion.
Can I put a little sharper point on that,
Yes,
Mayor?
please.
The appeal will not be dismissed because you've already determined that some folks, those particular appellants issue who are in that category would be dismissed from the appeal.
Correct. All right, so I'm going to call the question, starting with Commissioner Sernowski.
I vote yes for the same reasons I voted yes for the previous motion.
Commissioner Gay.
I vote no, and for this, I will just incorporate the statement I made earlier about the 1,000 square feet being part of the plan from the beginning.
Commissioner Gossett. Unmute yourself, Commissioner. Start over.
That would help. I vote no on this motion. Again, our code 236.6 does not require specific grounds. And I believe that the appellants living near within the 1,000 feet would be imminently aggrieved by the effect of this increased traffic, parking of patrons, etc. And also the Planning Commission used this as a criteria for outreach that is defined by them. And I'd also like to incorporate Commissioner Gay's comments into my thoughts.
Thank you. Commissioner Legree?
I vote no, and I will incorporate Commissioner Gossett and Commissioner Gay's thoughts and statement.
Thank you. Commissioner Byrne?
I vote yes for the reasons I stated with the previous motion.
Thank you. Commissioner Calusi?
I vote yes for the reasons that from my previous statement.
Thank you. And the chair also votes no, incorporating the rationale from Commissioner Gossett and Commissioner Gay, as well as comments I made earlier. With that, the motion fails. So would like to go on to the third motion, and that is I've entertained a motion to the appeal be dismissed due to lack of standing as to applicants who live more than 1,000 feet from the project. Do I have a motion?
I hereby move that the appeal be dismissed due to lack of standing to the appellants who live more than 1,000 feet from the project.
Do we have a second?
Second.
We have an original motion by Commissioner Legree and a second by Commissioner Dick Byrne, moving that the appeal be dismissed due to lack of standing as to the applicants who live more than 1,000 feet from the project. Open it for Commissioner discussion. Commissioner Gossett.
Yeah, I just feel that, Rehoboth Beach is a very unique city that we really only 1 mile square, and that the location of this project is at basically the traffic circle of the city. We have 2 entrances into the city of Rehoboth Beach, both of them feeding into the traffic circle. And with the added building, with more congestion of parking, of pedestrian traffic, that this will have a direct impact on all people that come in and out of Rehoboth Beach, not just adjacent and adjacent folks or 1,000 feet from the facility, but also everybody, because you have to pass through that area to enter into the city.
Thank you. Any other commissioners?
I'll make,
Oh,
go ahead.
Commissioner Gay, go ahead.
All right. Yeah, I agree with what Commissioner Gossett said. I just think that, the 1 square mile, most, if not all projects are going to affect, every property, especially projects of this size. And that's the whole point, is that one of the primary goals of site plan review is how a project affects the entire community. That's why we have site plan review. Only large projects go through site plan review. So almost by definition, they affect everyone. And I think the other thing that troubles me on this one is that, and I understand it's a harder, for the world at large, it's a harder issue because these people it's not as obvious that they're nearby. So you really do have to focus in on, the uniqueness of our community, but also the purpose of site plan review, which is the action field, I think. But what the other thing that's troubling to me is that I think it sets a dangerous precedent to deny standing to any of our property owners based on what I just said. And we've never done it, to my knowledge. We've never dismissed appellants, no matter where they live.
Thank you. Commissioner Calusi?
I have to say, I'm really saddened by the discussion here by Commissioner Gossett and Gay. They're talking about something that's so totally general about traffic in the city and how, we are a unique community. I would agree with that. But so we're going to start looking at a variety of, as we move forward in this city for any project, well, it's going to cause traffic. All I can see is the current majority of this commission voting against any type of progress in the city. Gee, let's not have runs at Grove Park because it's at the entrance of the city. Let's not have the farmer's market because it's at the entrance of the city. It's just,
Commissioner, I want to caution you to stay focused on the motions that are at hand, and I'm sorry.
well, I'm sorry. I just would totally disagree with Commissioner Gossett and Commissioner Gay because what they're speaking of is very general in terms of the effect on these particular appellants.
Thank you. Any other commissioners? Commissioner Gossett?
I just would say, I think that the comments made by Commissioner Calusi, those are dealing more with the merits. We are talking about standing here and for people that are affected by this project. Thank you.
Thank you. Any other commissioners? If not, I'd like to share my thoughts. You know, obviously, we don't have standing defined in any of the subdivision codes or even the tree codes, any other codes. And yet, Rehoboth Beach over the years and decades has been very accommodating to giving standing to people. In particular, I can cite the tree code. I believe there's been a case or two that, so there's been an appeal from across the city. And so I'm inclined to say that people that live more than 1,000 feet from the project, without defining what the maximum is, are able to have standing. Is there any other commissioner comment? If not, I'm going to close commissioner discussion and call the question. Again, the move was that the appeal be dismissed due to lack of standing as to the appellants who live more than 1,000 feet from the project. We'll start with Commissioner Gay.
I vote no for the statements and to incorporate the statements that I made and that Commissioner Gossett made.
Commissioner Gossett?
I vote no based on my previous comments.
Thank you. Commissioner Legree?
I vote no based on I incorporate the comments by Commissioner Gossett and Commissioner Gay.
Commissioner Byrne?
I vote yes, based on the reasons I stated under the first motion in regard to standing.
Thank you. Commissioner Calusi?
I vote yes for the comments that I made in the first motion.
Thank you. That leaves the chair. The chair votes no for the reasons I stated and incorporating rationale given by Commissioner Gossett and Commissioner Gay. With that,
Mayor,
the motion, with
Mayor,
that, the motion,
I didn't vote.
I'm sorry. I'm sorry. I still have a blank there. Commissioner Chernowski.
I vote yes for the reasons that I previously stated in the first two motions.
Thank you. And I'm recalibrating the votes, and indeed, the motion does fail. With that, we'll go to the next item of business.
I think I can shorten the next one.
Okay.
I think the motion would be for the commissioners to move to the appeal, I hereby move that the appeal be dismissed due to the failure of the appellants to indicate that they are appealing pro se and for not signing the notice of appeal.
You're combining 3 and 4.
Yes. So we can give one fewer motion.
We're going to combine, we're going to combine items 3 and 4 into a single motion. Again, they're in the affirmative. If I could get a motion, if we need to have Max repeat it, but essentially it combines 3 and 4 into one move. Go ahead, Commissioner Gay.
I hereby move that the appeal be dismissed due to the lack of standing of the appellants because they didn't affix their signature and because they did not indicate that they are appealing pro se.
May I suggest an amendment to your motion, Commissioner?
Sorry, yes.
Okay. Could you start with number 4? That would go something like, I move that the appeal be dismissed due to the failure of the appellants to indicate that they're appealing pro se and for
Okay.
not affixing their signature.
Okay. Do you want me to state it again?
If you wouldn't mind.
Okay, yes. I move that the appeal be dismissed due to the failure of the appellants to indicate that they are appealing pro se and that they did not affix their signature.
We have a second.
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 So we have an original motion by Commissioner Gay and a second by Commissioner Legree, moving that the appeal be dismissed due to the failure of the appellants to indicate that they are appealing pro se and for not affixing their signatures on the notice of appeal. So we have two topics for discussion and one formal vote at the end. I'm opening it for commissioner discussion. Well, I will offer, in terms of the part A and part B of this, I will be, let's see. Well, I don't believe either condition warrants rising to the level of the need to dismiss. Any commissioner comments?
I agree.
Commissioner Legree?
I agree. If the code, if the names are clear, if they're legible, and if they identify the appellants, I think that that's adequate.
Thank you. Any other commissioners? If not, I'm going to close commissioner discussion and call the question. Again, on the table is a motion that the appeal be dismissed due to the failure of the appellants to indicate that they are appealing pro se and for not affixing their signature on the notice of appeal. Commissioner Gossett?
Yes, I vote no because they have standing because they are imminently aggrieved. Delaware law does not require a layperson to identify themselves as pro se. The appellants are not required to obtain legal representation, and our code does not require each applicant to sign the appeal notice, only to indicate a name.
Thank you. Commissioner Legree?
I vote no for the reasons that I stated earlier and incorporating Commissioner Gossett's reasoning.
Thank you. Commissioner Byrne?
I vote no on this one. There's nothing in the code that requires a signature on the notice of appeal, and Delaware law does not require that a person identify themselves as pro se when filing an appeal.
Thank you. Commissioner Calusi?
I vote no for the reasons stated by Commissioner Byrne.
Thank you. Commissioner Stronowski?
I vote no for the reasons stated by Commissioner Gossett.
Commissioner Gay?
I vote no for the reasons stated by Commissioner Gossett and by Commissioner Byrne and others.
And the chair votes no, incorporating Commissioner Gossett's rationale. With that, the motion unanimously fails, meaning the appeal would not be dismissed.
We have a sidebar?
Yes, hang tight a minute, please. Since we're at the end of the first little session, before we start with the second, I'd like to recess for lunch. That means when we come back, we'll be able to hear the second non-merits preliminary motions, set of those motions in entirety, hopefully. And let's recess and reconvene at 12:40.
Okay.
With that, we are in recess. Thank you. All right, it is 12:42. We are back on the record. We have a problem on this end. We're going to need to take another 10-minute recess. Harvey, we need to talk with you. Are you available on your 466 number?
I am.
All righty. So again, expect a call from us. We're going to go into another 10-minute-ish recess, but my apologies.
Unforeseen, sir.
Thank you.
We're muted.
Hello, everybody. We are back on the record. It's 12:52 p.m. Something's come up and Max is going to address it with us.
There is a non-COVID related health issue regarding one of the participants of the appeal. It is a mandatory participant. And as such, I'm going to use my judgment to ultimately, we're going to have to move these motions to another date. While that's unfortunate, that date will likely be November the 12th, and I will need to confer with the other parties in the matter and try to get the scope of that. Commissioners, I'm sorry that this is going to happen because we were set to go this afternoon and gave the time, but it is the right thing to do under the circumstances. If anyone has any questions, you all have my telephone number, but I think the appropriate thing to do at this time is adjourn.
And as you suggest, this meeting is adjourned. Thank you all.
Thank you.
Those questions.